because of lawful artillery attacks. Even if we assume that this lawful attack had terrifying effects, a reasonable inference from the evidence is that the civilian population left because of the RSK's own anti-Croat propaganda and evacuation order. Even the prosecution witness, Ambassador Galbraith, testified that the side effect of the war was the departure but not the expulsion of the Serbs. To the best of my knowledge, this is the first prosecution ever in the history of international law where mass evacuation is equated with mass expulsion. Absent widespread unlawful attacks, to argue that Operation Storm was the cause of the exodus would be tantamount to saying that Croatia had no right to win the war because it would result in RSK evacuation orders. That would have to be the logic. In this regard, it is remarkable that a significant element of the prosecution's JCE theory is denial of the immediate mass return of the evacuated Serbs. At paragraph 35 of its brief, the prosecution states that, and I quote, "Led by Tudjman, the Croatian leadership adopted a no mass return policy, refusing to process group applications for return." End of quote. Let us examine this argument in light of humanitarian law. As set forth in paragraphs 569 to 571 of the defense brief, it is well established in international law that states have the right to expel enemy aliens during armed conflict. In response to the trial chamber's question, Mr. Tiger explained yesterday that the authorities we've cited are inapplicable to the facts of this case. In particular, he argued that the Eritrea-Ethiopia Claims Commission award held that mass expulsion of enemy aliens without individualized determinations are unlawful. I had the privilege of arguing that case before a tribunal presided by Professor Van Houte, and I can assure the tribunal that this is a correct understanding of the award. But we are not invoking this authority to justify a non-existent mass expulsion. We are only pointing out that if it is within Croatia's sovereign rights to expel enemy aliens, then it follows logically that Croatia is not under an obligation to allow their immediate mass return during an armed conflict. This is clearly a legitimate measure of national security, and it is difficult to imagine any state in similar circumstances anywhere in the world that would allow a policy of mass return for enemy aliens. The prosecution has not denied that the FRY was engaged in armed conflict with Croatia, which it considered to be an illegitimate state. It is not denied that FRY-RSK citizens were not and did not consider themselves to be citizens of Croatia. It may be argued that in relation to Croatia's succession to the SFRY, it had a customary law obligation to allow habitual residents that would otherwise become stateless the right to apply for Croatian citizenship. But obviously, those that pledged allegiance to the FRY-RSK and rejected Croatian sovereignty became enemy aliens. That was exactly the finding of the Eritrea-Ethiopia Claims Commission in relation to dual Eritrean-Ethiopian nationals habitually resident in Ethiopia. The present case is even more forceful because, unlike the case of Ethiopia, the FRY-RSK citizens were not dual nationals of Croatia. There was no question whatsoever about their allegiance to a hostile state that occupied a third of Croatia. Under such circumstances, it is totally obvious that Croatia was under no obligation to allow their immediate mass return. It is astonishing that this fundamental rule of humanitarian law was never considered by the prosecution until its closing argument in this case. It is yet another demonstration of the profound flaws in its JCE theory, that is to say, transforming a perfectly lawful no mass return policy into evidence of criminal intention. Another observation relates to the characterization of armed conflict issue. Mr. Tiger yesterday confirmed the prosecution's view that there is, quote, extensive evidence, unquote, that the armed conflict is international rather than internal. We fully concur with this view, and paragraphs 44 to 49 of our brief sets forth the facts that satisfy the overall control test of the Tadic appeals judgment. The problem is that the prosecution has never pleaded an international armed conflict in the indictment. Paragraph 56 of the indictment only states that at all relevant times a state of armed conflict existed in the Krajina region of the Republic of Croatia. The prosecution can therefore only rely on a non-international armed conflict to satisfy the nexus required for all counts in the indictment. The authority for this proposition is the Haji Hasanovic Appeals Chamber decision pursuant to Rule 72E as to validity of appeal dated 21 February 2003. The decision states in relevant part at paragraphs 11 to 12 that, and I quote, if the prosecution wishes to rely upon an international armed conflict, it must plead as a material fact that the armed conflict was international in character and state the basis upon which such an assertion is made. The prosecution should not be permitted to rely upon the imprecision of its current pleading in order to put forward a case that the armed conflict was international in character without a further amendment to its indictment to make this expressly clear. End of quote. And I note that this decision related only to Article 3 charges. There were no Article 2 charges involved. In this case, the prosecution has expressly stipulated that the conflict is international. But that is in direct contradiction with its pleading in the indictment that the conflict is non-international. As Haji Hasanovic indicates, it must satisfy the nexus requirement of all charges based on its pleading that the conflict is non-international. It is difficult to see, Mr. President, how the prosecution can reconcile this contradiction to sustain its charges. With the fundamental core of the Brioni JCE theory in counts 1 to 3 eliminated, a final consideration is whether the prosecution can still salvage its case with respect to remaining acts of plunder, wanton destruction, murder, and cruel and inhumane acts in count 4 to 9 of the indictment. We submit that it cannot. Since there is no proof of a JCE to commit mass expulsion, it is difficult to see how there could be a reasonable inference that there was a JCE to commit other post-storm crimes such as burning and looting that the prosecution claims were foreseeable within the scope of JCE Category 3, as we heard yesterday. If there is no Brioni JCE Category 1 or 2 with respect to mass expulsion, as claimed by the prosecution, then a derivative JCE Category 3 is simply irrelevant. Furthermore, the prosecution does not plead any JCE other than that at Brioni. A further consideration is that neither a persecutory policy nor the widespread or systematic element of Article 5 charges can be inferred from a mere crime wave. The prosecution refers throughout its brief to a post-storm crime wave. As set forth in paragraph 819 of the defense brief, states negotiating the ICC Rome Statute did not consider a mere crime wave to qualify as crimes against humanity in customary law. Consistent with the Kupreskic trial judgment, the ICC Elements of Crime stipulates that although a formal policy is not required, there must be at least, I quote, a deliberate failure to take action which is consciously aimed at encouraging such attack, end of quote. This is an onerous threshold that cannot be easily satisfied. It is not sufficient to demonstrate that Croatia did not plan adequately for the liberation of occupied territories, or that it had limited resources, or even that it had limited enthusiasm to prevent and punish crimes in the face of other wartime priorities. The only reasonable inference must be that there was a deliberate failure to act consciously aimed at encouraging such crimes, and we submit that the prosecution has failed to prove that case beyond reasonable doubt. Mr. President, I just want to advise the Chamber that the Cermak defense team has kindly agreed to give me an additional 5 minutes, so I will be wrapping up with that in mind.
Yes, which means that you have then 5 minutes left. Or would that be 7? Let's not talk in terms of seconds.
I will be
it
finished
may be
shortly.
clear to the parties that we want to conclude the first round of defense submissions in the final argument today. Please proceed.
As set forth by my colleagues, the evidence demonstrates that the UN Special Representative Akashi and other credible authorities did not consider the burning and looting to be part of a systematic campaign. The evidence demonstrates further that Croatia did not tolerate this crime wave, which resulted from lawlessness in the wake of the RSK's sudden collapse. Officials were clearly embarrassed by this conduct, which tarnished Croatia's international reputation. Notwithstanding the chaos of war, there were repeated orders and other measures, including 1,300 prosecutions, to prevent and punish such crimes. In this light, the allegation that there was a deliberate policy of failing to act consciously aimed at encouraging such crimes is certainly not the only reasonable inference that can be drawn. To accept the prosecution argument that a JCE is the only reasonable inference, the trial chamber would have to conclude that this was the conspiracy of the century, an act of such diabolical genius that a criminal policy permeating the entire Croatian state left no trace whatsoever. Of course, irrespective of whether there was a JCE or not, the only possible basis for General Gotovina's contribution to post-storm crimes, whether under Article 7.1 or 7.3, would be what Ms. Gustafsson alleged to be his deliberate, persistent inaction. But once again, the prosecution interprets humanitarian law so unrealistically that nothing that General Gotovina did could possibly be sufficient. The prosecution's basic allegation is that the many measures he took were merely a cover-up. As Ms. Gustafsson argued, Gotovina